Welcome back to another episode of Gimme Some Truth. We always love when we have guests on the podcast, and today we are lucky enough to have a French attorney who is going to help us with the questions that a lot of times come up, or frankly should come up, for people that are contemplating moving to France, mostly in regard to estate planning, real estate questions, things like that. Philippe from Squair Law, thank you so much for joining us. We really appreciate you taking the time today.
It's my pleasure for being here. It's really nice to have the opportunity to talk with you.
Absolutely. We're going to put Philippe's contact information in the description as well. So if you have further questions or specific questions that you'd like to ask, he's happy to answer those questions for you. We're going to try to answer a lot of those questions today, and there may even be additional podcasts that we film on the same topic, or even different French-related topics. So tune in for those as well. So let's jump into it. Just give us an overview, if you would, just a quick description, if you would, Philippe, of your background and kind of how you got to this point within French law.
Perfect. So I've been a tax attorney for more than 10 years. And all my career, I had a specific focus toward US nationals. I started focusing on US national at the previous firm where we were the expert in regarding the treatment of trusts in France. Trust is a common law concept, not a civil law concept. And since we were the only experts in this field, we came across a lot of US nationals having this issue. What should I do with my trust when I move to France, or if I own interest via my trust in France? And so I started advising on trusts, and then I moved to advising on US nationals, individuals, trustees of trust. And I've been doing this for the past 10 years and for the past 5 years at Squair Law.
Oh, fantastic.
Interesting.
We're going to hit a few different topics. Let's jump into estate planning. I'm a U.S. national. I moved to France. I pass away in France. What does that look like for me in terms of my estate? How do I mitigate the tax on that? Kind of start basic, if you will, in terms of what people can expect or what they should be thinking about, frankly, if they are contemplating a move to France.
Well, basically, if you do nothing, as I'm sure you're aware, French inheritance tax can be extremely high, depending on who inherits your assets. So, for example, if it's your children, the rate can go up to 45%. If it's, for example, a partner and you are not married or you are not in a domestic partnership, for example, the rate can go up to 60%. So, generally, what we recommend is implementing schemes before moving to France. To in a way mitigate French inheritance tax. There are several ways to mitigate French inheritance tax. One of the most common way under French law is the use of the division of ownership. It's in a way quite similar to what you have in the US, which is the life interest. In France, you can divide the ownership of an asset between the usufruct and the bare ownership. I will not go too much into details because it would be too complicated, but this scheme, if implemented, for example, on real estate, if properly implemented, you can enjoy an exemption of French inheritance tax. So this is one of the ways that you can use to prepare your move to France and to anticipate for your death, to plan for your death. And to make sure that, the money that you've earned and that you invested in French property goes to your children without the French tax authorities taking 45% or 60% of it, basically.
And that's interesting because, we talk to a lot of Americans considering moving to France, and it's true that France is kind of a funny destination for Americans because, in a way, the income tax aspect can be fairly benign, as you know, because of certain treaty provisions, right? So in particular, if you're a retiree, the income tax outcome on things like your Social Security, IRA withdrawals, and things like that may be actually pretty good. But oftentimes the way I kind of summarize the tax outlook for people is, look, income tax, good. Inheritance tax, bad, right? And so really, it's really that simple. And I think it's interesting for people to start thinking, okay, I understand the income tax aspect, but oftentimes people don't really consider the inheritance tax aspect, and that's by far the most punitive of the two. So I think planning ahead and considering things like gifts in Usufruct are very interesting solutions. Now there's another kind of question that comes up. It has to do with basic estate planning and not so much taxation, but maybe probate. And just a very basic question that we get is, okay, I'm moving to France. Do I need a will if I move to France? Do I need a will in France, or can I rely on kind of what I already have? What's your general take on that?
My general take is it's better to have a will made in France, even if a US will properly drafted, reviewed by the French attorney, can be quite effective in France. But it's often best to have a French will just to make sure that there is no misinterpretation about your desire, about the law that you want to apply to your succession. For example, a US national can choose to have a US law or the state where he resided before moving to France to apply to his succession. The idea, well, generally when I'm asked this question, the first comment that I get is how to avoid a French forced heirship rule. Under this rule, I mean, in France there is no equivalent to the freedom of testation that in the US. In France, a part of your estate is reserved to certain heirs, and there is no way around it. The only way around it, which is open to foreigners, is to opt for the law of your country of origin to apply. So often I recommend either make a very good US will and have it registered in France, or have it somewhere in France where it can be found, or just make a French will and make sure that in your will you opt for the law of the US or the state where you lived before moving to France, to avoid French forced heirship rules to apply. The goal basically is to ensure that your desire that you've expressed in your US will are applied in France. So I would say it's not mandatory, but it's an additional safety net to have a French will.
Yeah, and I think the French will is important. I think the election that you mentioned, another point of confusion that we see sometimes is people think that the election somehow has tax implications, but it's not a tax-related election. It's purely something that relates to probate proceedings and the law that applies to the distribution of your estate. It can indirectly have tax implications, but it doesn't change your exposure to French inheritance tax. I think I just wanted to highlight that because sometimes people think it's a way to get off the hook as far as French inheritance tax, but it obviously isn't.
Yes, exactly.
Yeah, and I think that the common theme that'll end up running through this podcast is the idea that if you think that you can handle this on your own, you probably shouldn't, and you probably should seek the advice of an attorney, Philippe, like yourself, in terms of making this move, and preferably before you even make the move, that you would have these conversations and really understand where you're at, because as we see with clients that move overseas, there are a myriad of things that need to be taken care of by way of logistics and everything else. This is not something that you want to just gloss over and kind of get to later. You want to figure this out pretty quickly.
And also, it's a very personal thing. It's a very individual thing. So every situation is going to be different. And I would encourage viewers that even if they hear Philippe give a particular kind of share a particular thought or comment, that you always have to work with a professional to make sure that those comments are actually applicable to your situations. And there may be cases where the election of French law, for example, is valuable, or U.S. law is valuable. Other cases where maybe not so much, right? So everything has to be looked at from the perspective of your own personal circumstances.
What I often see is that when we speak with U.S. nationals moving to France, they tend to look at, for example, their will from a U.S. perspective. So they forgot that once they will be in France, everything will need to be looked at from a French perspective. So a will that's on the paper is a very good will in the US that complies with all the requirements. Unfortunately, often it's not the case under French or European law. For example, someone moving to France, then move to Spain. You also have to take this into consideration. You have to be compliant with the European law and French law. And this is quite often forgotten. And unfortunately, it's done after moving to France. Well, the best time to act is actually 3 or 6 months before moving to France. Whether it is for income tax, estate planning, inheritance tax, everything needs to be done at least 3 months before moving to France, ideally 6 months before moving to France.
Okay. Let's switch gears just slightly over to trusts. Trusts are very common, popular, talked about a lot in our world, our conversations with clients here in the US. Just in general, for somebody moving to France, what's the kind of the first blush reaction to trusts, just in general? And then also, I have a US trust and I'm moving to France, now what? You know, how do we answer those questions?
Basically, in the past, the trust was seen as a tax evasion scheme by the French tax authorities. So the general reaction that you would get from a French tax attorney or estate planning attorney in France was get rid of your trust. It's no longer the case. I mean, not necessarily. There was a law in 2011. And the purpose of this law was in a way to integrate trust into French law, not into French civil law, but into French tax law. So the purpose of this law was basically to provide people with a set of rules on how to deal with trust. So for each type of tax, you have a different rule. Sometimes there is no logic to it, sometimes there is a logic to it, but at least there is a clear picture of how trust should be treated and handled in France. Now, regarding the tax implication, to summarize, there is a very big difference between being, for example, the grantor or the settlor of a trust and being the beneficiary of a trust. The tax implication of being a grantor of a trust can be negative in France. There can be adverse tax consequences in France, especially regarding income tax, due to the different treatment that may apply in the US and in France. Basically, the income may not be taxed during the same year. There may be a discrepancy between when it is taxed, and the tax treaty may not prevent the double taxation of an income that is earned via a trust. This is, I would say, the big no for having a trust as a settler. As a beneficiary, being the beneficiary of a trust and being a French tax evidence per se is not an issue. As long as the trust agreement complies with French law, as long as you report the distribution, as long as you comply with the reporting requirements in France, the French tax authorities will not. I mean, I often get the comments that I'm the beneficiary of a trust, I will be audited by the French tax authorities every 2 years. In practice, that's not true. The French tax authorities know that the use of a trust is something quite common in the US, in the UK. So if you comply with the reporting requirements, if you have nothing to hide, there will be no adverse tax consequences in France of being the beneficiary of a trust. It's a little bit more complicated if you are the grantor of a trust, but there are ways to mitigate these adverse tax consequences that may apply for grantors of trust.
Interesting, because I mean, it's true that trusts are so common here in the U.S. It's kind of the default estate planning mechanism that we use, and so many people just do it without even thinking about it because it's kind of the default option and best practice, but just worth reviewing at least before you move to France. But it's true that, you know, your point about the reporting requirements is very important, I think. And the tricky thing for beneficiaries of trusts is the reality is you could be the beneficiary of a U.S. trust and not even know about it. So you have to make sure that you have all the information to disclose. But there are, even if the tax consequences are pretty benign, there are reporting requirements that people need to at least be aware of before moving, ideally.
So do you see that a lot of our clients that are going to move to France, do they have a good handle on this area of French law, or is this something that we assume because of U.S. law, right? And then we apply those assumptions incorrectly?
Not really.
Okay.
I think this is where knowing professionals like Philippe is extremely valuable, because it's still a very complex question, and in a way Philippe makes it sound almost simple, but that's because he's been doing it for over 10 years. But there's a lot of very granular details and question marks along the way that I think need to be addressed. And I think the general level of knowledge and understanding is pretty low, and that's because ultimately it's still a very complex area of international taxation and finance.
Philippe, on this topic, what would you say is the most misunderstood, assumed but incorrectly assumed area of estate planning for U.S. nationals coming to France?
That's a good question. I would say, often what I see is that, the most common thing I would say that I see is that often there is a confusion between the income tax treaty and the estate tax treaty. First, many people that I meet are not aware of the estate tax treaty between France and the US. They are aware of the income tax treaty. So when we tell them that there is an estate tax treaty and there are ways to use this tax treaty to mitigate their exposure to French inheritance tax, they are often surprised because, well, simply they are not aware of it. I would say the second confusion that I see is that often people assume, or US nationals assume, that due to the very favorable treatment that they get under the provision of the US France income tax treaty, the same treatment will apply to them for the US France estate tax treaty. To give you an example, I recently met with someone holding a French apartment in Paris. And he assumed that being a US national holding a French real estate, you would not be liable to any taxes in France. He assumed that his liability would be only in the US. So yes, there is a confusion between these two tax treaties, and there is also a misunderstanding on how a French tax law works with this tax treaty. Another big aspect that I see is that the use of trust. Simply the use of trust. When the way French law works is that since trust is unknown under French civil law, the rule is that for inheritance tax, a trust is disregarded. So if you own assets in France without trust, it will be subject to the French inheritance tax. And often when we try to explain this to our clients, they do not understand why. Because in their mind, they are no longer the owner of these assets in a way. And I do not understand why France would tax such assets.
And that's kind of your point about real estate and the Paris apartment is also interesting, because when we talk to Americans moving to France, what we find is oftentimes real estate is a big part of their plan and their reason for moving to France. And maybe before we wrap up, we can touch on real estate a little bit, because I think France has a lot of very attractive properties, I think, for foreigners, and people see it as a pretty attractive property market. And there's a lot of different lifestyles, whether you want a Paris apartment or a nice house in the country. And certainly if you, especially if you live in the US here in one of the more expensive metro areas, French real estate could look relatively cheap, right? So I think a lot of people, part of their project in moving to France and part of their plan very much centers around real estate and around, buying kind of their dream home, right? So to speak, their dream retirement home. So are there things that, kind of people should think about in terms of buying property, whether that relates to French taxation or kind of French probate and inheritance mechanisms that they need to be aware of as it relates specifically to real estate purchases in France?
So yes, basically you have to distinguish between two situations: whether or not you intend to retire in France and become a tax resident, or whether you just intend to acquire a property in France and use it as a holiday home. These are two different situations, and the structuration of the acquisition of real estate changes drastically. If you intend to retire in France, you need to use French scheme to acquire this real estate, but you need to implement this scheme before moving to France. The most common scheme is well, basically the division of ownership. You acquire the usufruct, your children acquire the bare ownership, or you give the bare ownership to your children. But this needs to be done before moving to France. If you do it while you're in France or after acquiring the property, then you are subject to French gift tax. So in a way, it's too late. It's too late if you want to do it efficiently. It's too late. So this must be done before moving to France. So I would say this is the most common used scheme in France by French nationals, by foreigners. It's a scheme that is agreed on by the French tax authorities. They clearly stated that they have nothing against it. So it should be used and it should be implemented properly. If it's done properly, there is no issue with it. The second situation, if you have a holiday home in France, often what I see when I talk to clients, they are already acquired the property. Again, it's too late. You must think about how to structure the acquisition before acquiring the property. But details that I often see, people often tend to acquire the property itself. And often in France, properties can be owned via a company. In France, doing a share deal instead of an asset deal can be way cheaper. You can save notary fees, you can save registration duties. If you acquire the shares, for example, of a French real estate company instead of the property itself, you can save thousands of euros in taxes just upon the acquisition. And acquiring the shares of an entity instead of the property itself also allows for more possibilities in structuring the acquisition and for estate planning. So, but again, the key factor here is to do it or to think about it, not when you have already made an offer on a property, but when you start looking for the property. This is the best time to think. So when you found the ideal property, the structure is already ready to be implemented. This is the ideal situation. And also, something that I want to stress about, a mistake that I often see, is that if you acquire a property in France, get your own attorney and get your own notaire. I often see clients using the notaire or the attorney of the seller. I mean, it's not the proper way to proceed. You want someone that represents you, that represents your interest, that make sure that what you are acquiring actually correspond to what what you're acquiring on the paper actually corresponds to what you visited, correspond to the pictures. You do not want to discover 6 months after acquiring the property that, for example, there is a droit de passage, which is a right of way of a neighborhood on your property. So this is something that we can also assist with, that the notaire will assist with. But if you use the notaire of the seller, there is a chance that he may not see it because it is not necessarily only representing your interest. So always get your own counsel, get your own notaire before proceeding to any acquisition of real estate in France.
We would be remiss, Philippe, if we didn't, before we end, get your thoughts on France's chances in the World Cup. So give us 30 seconds on, is France going to win the World Cup? Right now, Philippe's going to tell us if France is going to win the World Cup.
Well, I hope so. I was a kid when France won the World Cup in 1998. It was a great year. For me, it was the best year.
That was a great team. Let's hope so. Same age. So yeah, that was special.
That was a very special year. And if I could have the opportunity to experience again, or for my kids to experience again the same ambience in France, that would be great.
Yeah. Well, we hope to talk to you before they settle it on the pitch, but if we don't, we'll find out, who raises the cup. But thank you so much for your time today, Philippe, and your information. And I think it's great to talk to somebody that's in France and says the same things that we do in terms of prepare, get the information, talk to the professionals that know what they're talking about, really make sure that you're represented correctly, because ultimately these decisions in our world don't work the same way both ways, right? The minute we go forward doesn't mean we can go backwards and kind of, fix that mistake that we've made. So before we take that first step forward, reach out to Sil, myself, people like Philippe that know this information and can guide you correctly. So once again, thank you so much for your time, and thank you for watching another episode of Gimme Some Truth.
Walkner Condon Financial Advisors is a registered investment advisor with the SEC. Registration with the SEC does not imply a certain level of skill or training. The opinions expressed by the participants of this podcast are their own and do not reflect the opinions of Walkner Condon Financial Advisors. All statements and opinions expressed are based upon information considered reliable, although it should not be relied upon as such. Any statements or opinions are subject to change without notice. Information presented is for educational purposes only and does not intend to make an offer or solicitation for the sale or purchase of any specific securities, investments, or investment strategies. Investments involve risk and, unless otherwise stated, are not guaranteed. Information expressed does not take into account your specific situation or objectives and is not intended as recommendations appropriate for any individual. Listeners are encouraged to seek advice from a qualified tax, legal, or investment advisor to determine whether any information presented may be suitable for their specific situation. Past performance is not indicative of future performance. Thanks for listening, and for further information, please visit WalknerCondon.com.